Some time ago, you dismissed the applicability of the major questions doctrine.
The major question doctrine.
The major questions doctrine.
Major questions.
Major questions.
For major question purposes.
That's not the Supreme Court promoting a new TV game show. That was oral argument in the case over Donald Trump's tariffs, where lawyers and justices said major questions doctrine 24 times. The major questions doctrine is a legal principle that the court has increasingly invoked in recent years. It has become a central feature of its administrative law decisions. But some critics argue the doctrine shifts power from federal agencies to the judiciary. The major questions doctrine boils down to a fairly straightforward principle.
Courts should demand clear statutory authority anytime an agency seeks to undertake to exercise its power in ways that have implications that are hugely significant.
That is, if Congress intended a government agency to have the authority to make a rule or regulation on an area of major concern, it would have clearly and unambiguously stated so in the statute. Or, as Justice Kavanaugh, invoking a famous Antonin Scalia phrase, explains.
The idea is Congress doesn't ordinarily hide elephants in mouse holes. In other words, do some massive new authorization in some ancillary provision or some provision that's vaguely worded.
The upshot? Under the major questions doctrine, courts, not the president or federal agencies, will have the power to determine whether Congress clearly authorized a major executive or agency action. Take a 2022 case. It was over whether the EPA had the authority to regulate greenhouse gas emissions in a way that could force coal-fired power plants to close. In a 6-3 decision, the court ruled that Congress had not given clear authorization to do so. Chief Justice John Roberts stated there was little reason to think Congress assigned such vast power to the EPA. It was the first time the court had formally articulated and applied the major questions doctrine in a majority opinion.
Courts have always had to grapple with how to interpret the statutes that Congress passes, and in particular, how to interpret statutes that apply to and govern the work of administrative agencies.
Legal scholars disagree on the origin of the major questions doctrine. Justice Kavanaugh pegged its intellectual beginnings to an unlikely source.
And you used the 1986 law review article by, albeit, Justice Breyer.
Breyer was frustrated that under the Chevron doctrine, courts were often required to defer to agencies when a statute was silent or ambiguous. Breyer advocated for a more flexible approach, where courts are reviewing major agency actions. But other legal scholars say the doctrine's underlying principles trace back to the country's founding.
This is a power that courts have had from almost to the very beginning of the courts system in the country after the Constitution was adopted, for courts to read statutes narrowly in this way.
So how does the Supreme Court understand the major questions doctrine? The justices themselves are still hashing it out.
Well, I think there are, and I will say, competing views on the court about what the major questions doctrine is.
In the EPA case, Justice Gorsuch wrote, administrative agencies must be able to point to clear congressional authorization when they claim the power to make decisions of vast economic and political significance.
It is clear, it says, we want the president to decide this issue, then that would not raise a major questions doctrine.
Which raises a major question about the major questions doctrine.
How major is major? You might think something's major, I might think something's major. There's just a lot of sponginess to this so-called doctrine.
This is not a black and white on-off situation. There are degrees of majorness.
Under President Biden, the court determined that several agency actions were both major and lacked clear congressional authorization. It used the doctrine to invalidate much of his administration's regulatory agenda.
A major decision by the Supreme Court blocking the Biden administration's temporary ban on eviction.
The conservative justices in the majority said the president overstepped his authority when he tried to cancel up to $400 billion in student loans.
The court's liberal justices accused the conservative majority of wielding the doctrine for purely ideological purposes.
Judges can't be rewriting statutes to fit what they would want to do.
Which brings us back to Trump's tariffs case. Would the conservative justices apply the doctrine to a major action from a Republican president?
The Supreme Court ruling the president does not have the authority to impose some of his sweeping global tariffs.
In the 6-3 decision, only 3 of the 6 conservative justices applied the major questions doctrine to the case. They sided with the court's liberals, who applied a different rationale to strike down the tariffs. The conservative split showed that even the doctrine's proponents don't necessarily agree on when and why the court should apply it.
Is this really a doctrine if at the end of the day it's going to just depend upon what 5 justices happen to think is going too far?
While the justices are still debating how to apply the major questions doctrine, one thing is clear: it isn't going away anytime soon. So next time you listen to a Supreme Court argument, you may hear another round of Major Questions Doctrine, the game show.